All right, let's jump right in. We're headed to a place called Trilogy at Vistancia. It's an age-restricted planned community out in Arizona. So you can picture it, right? It's a quiet, kind of exclusive neighborhood where things are supposed to be, well, pretty peaceful. And the crown jewel of this place is the Kiva Club. I mean, look at this. It's a massive 35,000 square foot clubhouse with pretty much everything you could want. A fitness center, pools, the works. It's built for comfort and relaxation. Which brings us to the big question. How does somebody living in a place like this get themselves banned for 60 days from all of it? It's a crazy story, and you know what? It all started with a golf cart. Our story kicks off right there, at the entrance to that very club. Let's really set the scene for the incident that lit the fuse on this whole thing. So, let's meet our main guy, Stuart Kirschner. The date is September 18th, 2011, and this is super important. Mr. Kirschner is recovering from a major hip replacement. We're talking just 3 days off a walker. So he's not exactly feeling his best, and he's having a really tough time just moving around. This is absolutely key to his whole state of mind. Now, here's where it gets really interesting. What happened next? Well, that totally depends on whose story you believe. We have two completely different versions of the exact same 30-second interaction. Okay, so on one side, you have Mr. Kirschner. He says he was just plain frustrated. He couldn't find a handicapped spot, he's in pain, and he sees this golf cart parked right near the entrance. He fully admits he asked the sales associate, a Miss Kelly Young, to move her damn cart. But then you hear from Miss Young. She says she's in the middle of giving a tour to potential buyers when Mr. Kirschner comes up, yelling, swearing, and causing a huge scene. Her words, she felt embarrassed, shaken, and honestly even fearful. And to his credit, Mr. Kirschner did offer up some context. In his own testimony, he straight up admitted he'd taken pain meds and was feeling, as he put it, tired and testy. But here's the thing. There was a witness. The general manager of the whole development testified that he saw Ms. Young right after the whole thing went down, and he said she was, quote, visibly shaken. That little detail, it really seemed to back up her side of the story. So you've got two conflicting stories and one really upset employee. The whole mess gets taken out of their hands and put right into the formal process of the homeowners association. Let's see how they handled it. And the HOA, they didn't waste any time. Just 2 days after it happened, boom, a notice of violation. They did grant him a delay for his hearing because of his surgery, but they also suspended his club access while they sorted it out. Then, on October 10th, Mr. Kirschner does something huge. He emails them and waives his right to a hearing. Just 11 days after that, the board found him in violation and made the 60-day suspension official. So you've got to be asking yourself, why? Why would he give up his only chance to tell his side of the story? Well, according to his testimony, he felt like the whole process was a sham. He basically believed the HOA had already decided he was the bad guy. So, after the board makes its ruling, Mr. Kirschner tries to appeal it, but he gets shut down. He was told that, according to the community's own rules, the board's decision was final. That's it. No more appeals. And that's the moment this whole thing gets kicked up a level to an administrative law judge. All right, so after all the drama, all the back and forth, how did a totally neutral third party see it? Let's get to the judge's final ruling and see how this all wraps up. Now, before we dive into the verdict, you gotta understand the legal standard here. This wasn't a criminal case, so it wasn't beyond a reasonable doubt. The standard was preponderance of the evidence. All that means is the judge just had to decide which story was more likely to be true. It's a much lower bar. So the judge broke it all down into 4 simple steps. Step 1, did a violation actually happen? Yes. The judge found Kirschner's language was abusive and broke the rules. Step 2, did the HOA follow its own process? Well, since Mr. Kirschner waived his hearing, the answer was yes, they did. Step 3, was the punishment reasonable? The judge said the 60-day suspension was justified because the behavior could be considered a danger to others. And finally, step 4, the big one, the judge confirmed that the HOA's own documents say the board's decision is final, period. And with all that, the judge's final order was about as clear as it gets. Petition dismissed. The HOA doesn't have to do a single thing. Case closed. So after all that, what can we learn from this one really specific, really personal fight? Well, it actually has some pretty big lessons for anyone who lives in an HOA, or is even just thinking about it. This case really drives home a few key things. First, those HOA governing documents, They're basically the law, and when they say a decision is final, they usually mean it. This also shows that giving up your right to a hearing is a huge risk with serious consequences. And while your personal situation might explain why you acted a certain way, it might not excuse you from breaking the rules. And finally, always remember, these things often just boil down to that one simple question: which story is more likely to be true? The whole story leaves us with one last, kind of provocative question to chew on. When you sign on the dotted line to join an HOA, you know you're agreeing to its rules. But are you also, without really thinking about it, agreeing to its judgment, even when you feel it's totally wrong? It's definitely something to think about.